Hi and welcome to munshigiri.com. In this tutorial, we are going to start with the essential elements of Indian Contract Act. The essential elements of a valid contract are contained in section 10 of Indian Contract Act. So we have section 10 for essential elements of a valid contract. First of all, the word essential refers to a thing which is absolutely necessary. So all the elements prescribed under section 10 of Indian Contract Act must be present cumulatively. Only then it will become a valid contract. Now remember the diagram that I taught in the last session? It appeared like this. There is a contract. It has two elements. Agreement and enforceable at law. Again, agreement has the offer and acceptance. There is an offer and acceptance. And here you had consideration. So some of the essential elements emerge from this diagram itself. First of all, there must be an offer, and the said offer must be accepted by the other party. There must be consideration, and the consideration should be lawful. Another is agreement, and the said agreement must be enforceable at law. Okay. So these were some of the basic essential elements. Moving on to the other elements. See, the first one I have already covered. I am talking about this one here. An offer or proposal by one party and acceptance of that offer by another party resulting in an agreement. Moving on to the second one, an intention to create legal relations or intent to have legal consequences. Now the parties to the contract must intend that the agreement should be attached by legal consequences and create legal obligation. Agreements of social or domestic nature do not contemplate legal relations, therefore they do not give rise to a contract. We'll cover a case here that is a very famous case, Balfour versus Balfour. Let's look at this. This is intention to create legal relations. Agreements of social or domestic nature do not contemplate legal relations. Therefore, they do not give rise to a contract. Therefore, they do not give rise to a contract. We refer the case here, welfare versus welfare. What were the facts of this case? The facts of the case were a husband promised to pay his wife household allowance of 30 pounds per month so long as they remain separated. In this case, a husband promised to pay his wife household allowance of 30 pounds per month so long as they remain separate. Later on, the husband failed to pay the allowance. Later on, the husband failed to pay the promised amount. And what the wife did? The wife brought an action to enforce it. The wife brought an action to enforce it. In the given case, the wife will not succeed. The wife will not succeed. Why? Because they did not intend to create any legal relations. The wife will not succeed because they did not intend to create any legal relations. And it was merely an agreement of domestic nature. So that was our discussion on the point intention to create legal relations. Coming to the next point. The next point is the agreement is supported by lawful consideration. An agreement made in the absence of consideration is void. This is the point we're discussing now. Consideration. What is consideration? It is the price paid by one party for the promise of the other party, but only those transactions are valid which are lawful. Moving on to the fourth point, That is, the parties must be competent to contract. Let's look at this point now. This is parties must be competent to contract. This is covered by Section 11 of Indian Contract Act. Now listen to what Section 11 talks about. Section 11 says that every person is competent to contract if he is age of majority, is of a sound mind, and is not disqualified from contracting by any law to which he is subject. Now let's see what it is. This section says every person is competent to contract if he, first point is of the age of majority, that is a person who is above the age of 18 years. Second point is of unsound mind, is of sound mind, and third is not disqualified from contracting by any law to which he is subject. So, a minor, a person of unsound mind, and a disqualified person is not competent to contract. Let's look at an example here. Now there's Mr. X who agrees to sell government property. Mr. X agrees to sell what? Government property to Mr. Y. And Mr. Y agrees to buy the government property from Mr. X. It could not be treated as a valid agreement as why? Because Mr. X is not the authorized owner of that property. Not valid as Mr. X not authorized owner. Of the property. Coming to free consent. Free is without any domination and consent is judgment. So you have free and consent. Free is without any domination and consent is judgment. When the judgment of a person is not affected by CUFMM, the consent is said to be free. What I just said was when the judgment of a person is not affected by 5 things. First is C, second is U, third is F, fourth is M, and fifth is also M. Now, what do you mean by C, U, F, M, M? C is coercion, U, undue influence, F is fraud, M is misrepresentation, and another M is mistake. So if any of these elements C, U, F, M, M is present in an agreement, the consent of the person is not said to be free. Okay, I'm going to explain the meaning of these terms later on, but for now just understand that if any of these elements is present, the consent of a person is not free. In the case of first four elements till misrepresentation, if contract is affected by these, if contract is affected by these, it is voidable. And if contract is affected by mistake, then it can be valid or void or voidable, depending on the type of mistake. So this was about free consent. Moving on to the next element is the object of the contract is legal. Any act which is prohibited by law will not be valid. This is a self-explanatory point. Coming to the next one, certainty of meaning in an agreement. The wordings in an agreement must be clear and not vague. Let's look at an example for this. This is certainty of meaning in an agreement. Certainty of meaning in an agreement. What do you mean by this? The wordings of the agreement must be clear and not vague. For example, Mr. A, there is Mr. A who deals in a number of oils. Mr. A is an oil dealer. He agrees to sell 100 tons of oil to B. Now, since the kind of oil is not specified, the agreement is void for uncertainty. Kind of oil is not specified, so we can say that the agreement is void for uncertainty. Okay, coming to the next element, essential element that must be present is The agreement is capable of being performed. That is, it is not impossible to perform an agreement. Self-explanatory point again this is. Next is consensus ad idem. Coming to this point, consensus ad idem. Let's discuss this point, what it means. This is consensus ad idem. What is consensus ad idem? It means meeting of the mind in the same sense and same thing or time. Same thing or time in full and final settlement. Okay. Consensus, that is consent. Ad idem, that is having a consent on the same item. That is, the minds of the persons meet in the same sense and same thing in full and final settlement. Let's look at an example for this. A person has 2 cars which he wants to sell. Okay? A person has 2 cars which he wants to sell. He has, let's say, one Swift car and another he has Nano. Okay? He does not specify to the buyer which of the 2 car he wants to sell. Now in this case, suppose the buyer wants to buy Swift. Okay, now there is no identity of mind in this case. Therefore, in the absence of consent, there is no agreement. Say, he does not specify as to which car he wants to sell. The buyer intends to buy Swift. There is no identity of mind in this case. There is no identity of mind in this case. Therefore, in the absence of consent, the agreement is void, or there is no agreement. This was about consensus ad idem. Moving on to the next element we have is 10th element, agreement not expressly declared void. Now there are some agreements that are expressly declared as void. Agreement should not be one which is declared as void. Agreement not declared void. Now there are some agreements that have been declared void, like you have the agreement in restraint of trade, Then you have agreement in restraint of marriage, agreement in restraint of legal proceedings, etc. These agreements have been declared. There are a number of other agreements also which have been declared as void. The agreement should not fall in any one of these categories. We're going to discuss about the agreements which are declared as void in the later slides. Thank you.